Now, when you are in court and you are looking at proof, proof is tested. That's the method of assessing it. You test the proof. And with witnesses, two questions normally arise. The first is accuracy. Is the witness accurate and reliable or not? You all know people who are muddled, who are vague, who are inattentive. You can get distracted by having some object in the way, a hedge or a fence or another person. You can be distracted by something else that's happening and your attention isn't on the event. All those practical common sense questions of accuracy and reliable regularly arise in courts. And in fact, most witness cases in cross-examination are directed to that first point. Is the witness accurate and reliable or not? Now, that doesn't get a run on television much because it's not as dramatic as the second category, but it's the normal question of witnesses. Are they accurate and reliable or not? Can they be relied upon or not? The second question is truthfulness. Is the witness a deliberate liar? You do get liars. You don't get a lot of liars, but you do get liars in court for both sides, for the prosecution and for the defence in a criminal case, for the plaintiff and the defendant in a civil case. And the question is quite different to whether you're accurate. It's a question of whether you're deliberately lying or not. And that's the one that you see mostly on television because it is much more dramatic. But they're the two categories of assessment of witnesses. And the method of testing is this. First, the witness gives their evidence. It's called evidence in chief. It's led by their own lawyer. And then the other side cross-examines that witness, and that's cross-examination. Now, cross-examination is very important because it is the method of testing the witness evidence. And it's quite a proper and valuable part of the legal process. But the law, and in particular the courts, have badly fallen down on limiting cross-examination because cross-examination should be permitted and indeed encouraged to test, but it should never have been allowed to cross the line into bullying, into sarcasm, into denigration, into abuse, into shouting. And the courts have an unfortunate history of not drawing that line clearly. Particularly in sexual offence cases, you all know the notorious cross-examinations of particularly younger women in sex cases. Sarcastic, demeaning, sneering, bullying. That should never happen. The courts are getting much better at drawing that line. Test, yes. Abuse, no. But that distinction is a very important one for you to embrace because it is important that witnesses are tested. A, are they accurate? B, are they truthful? But they should never be bullied, and judges need to step in and stop bullying. We've been too slow on that. We're getting better, but we're not starting from a high base.